She asked him to keep the dogs away. He didn't do that, he lied. The youngest is scared of the dogs and he's been bitten previously twice.
For 6 hours on a Saturday, just keep them away from the children. This isn't rocket science.
When reviewing his D81 and all this paperwork, it's actually got inaccuracies. I either agree or I will be threatened with this notice of show cause.
Your success in your case, Preet, will lie in why. That's how you're going to determine if your application will be successful.
I need to force the sale of a property. I'm 74 years old. I cannot use the steps anymore. I just can't afford to wait any longer.
The big thing for me, Gabrielle, is hey guys, and welcome back to the Legal Queen live show. I am your host, Tracy Maloney, aka the Legal Queen on social media. I am a practicing family law solicitor and have been now for over 20 years. During that time, I've helped thousands of people with their family law applications, whether that be around divorce, finance, or perhaps child custody. If you think that I could help you with a question or query that you might have because maybe you're looking to make a family law application, then please join me in the Legal Queen Discord channel. Come into the Legal Queen Lounge, pop your hand up, and I'll be sure to get to you. Now enjoy the show.
My grandsons have an interim court order to spend time with their dad.
Yes.
But there's been issues in the past with dog bites on the youngest.
Yes.
My daughter's tried to raise this issue because she asked him not to keep the dogs away. And he didn't do that, he lied, and she's now had to contact social services. But they're due to go back again on Saturday.
Yes.
She's already been in trouble for not following the court order. So can you give any advice on what she should do? Like, because social services said they can't tell her, they can't get involved in the legal side of it.
So, sorry, what does the court order say at the moment that's being breached?
It says that the boys are to spend time 6 hours every other Saturday with their dad.
Right. And why is she concerned about that? Sorry, because of the dogs?
Because the youngest has had, they've got dogs.
Yes.
And the youngest is scared of the dogs. And he's been bitten previously twice that we know of.
I understand.
And he didn't keep the dogs away and he's lying about it and... You know.
So has Mum had a conversation with Dad about this? You know, if it's only 6 hours, and Dad has said no, he won't keep the dogs away.
He's saying he kept the dogs away, but he didn't keep the dogs away. Both the boys have reported that they spent time with the dogs. Okay, so she's well within her rights. If we have a safety issue, and clearly we do, if one of the children have been bitten twice, to say to Dad, look, the children are telling me that the dogs are still there, and whilst I don't want to stop the routine of you having contact with them, I'm going to have to. Because the children are terrified of the dogs, which means that they're not enjoying their contact time with you. But more importantly, we risk them being bitten again. So I think she's well within her rights to do that. Now, if then Dad takes the matter back to court, I guarantee that a judge will simply say, get the dogs out. Like for 6 hours on a Saturday, just keep them away from the children. This isn't rocket science. This isn't really a legal issue, if I'm being completely honest with you. This is just co-parenting again. Yeah. Very difficult situation.
It is. But, tell her not to be concerned if she decides to breach the order because she's doing it because she has safety concerns for the children.
Hi. Yes, I spoke to you before, but I've now decided to act. The problem is I need to force the sale of a property. Now, I will have to email you because we're not married. And I think you said that's more complicated.
Yeah.
But I still would like to have some information quickly.
Yes.
He has refused to sell for a long, long time. He doesn't even talk to me. We're still in the same flat. I'm 74 years old. I cannot use the steps anymore. He's totally aware of all that, but he just simply turns around and says, well, I can't find anywhere else to live. Now, when I take him to court, which I now probably will have to, is there a way of making sure that I have control over the sale and everything else, because he will just delay it. He will come up with new excuses, and I just can't afford to wait any longer.
Sure. The answer to your question is absolutely yes. Yes. I mean, where we have a history of somebody not wishing to engage, not wishing to negotiate, not wishing to move the matter forward, absolutely. We can let the court know of that, and we can build in provisions that will protect you against that delay in the future. So yes, the big thing for me, Gabrielle, is I'm just itching to ask you so many questions because, and obviously I can't on this forum, because I really want to understand the history, the relationship, and what's happened up to this point. So please, if you want to go forward, drop me an email and let's get an appointment booked up in the diary.
Oh, I absolutely will.
Okay.
Just one more question.
Sure.
If I start the ball rolling basically now, how long will it take before it will actually be in court, or before I get a date for the court hearing?
Estimate about 3 months for your first hearing date. From when we make the application, it usually takes us about 3 months.
Okay.
All right.
That's great. I'll get in touch with you.
Okay.
Then.
I'll speak to you soon. Thanks, Gabrielle.
Okay.
Bye-bye.
Bye.
Matthew, let me come to you next. I'll just take you off mute. There we go. How can I help?
Oh, hiya. So what it is, I've been going through family courts for the past 3 years to get a child arrangement order.
Yeah.
And it was going through a contact centre because Kafkas were involved, and I basically used to use sort of like a little bit of cannabis here and there with my friends,
Yeah.
which I stopped. And I did a hair strand test last year, which was 2 months negative. And then in January, I went back to court, and Kafkas just said that, yeah, no, we pretty much need sort of like nearer 6 months negative, which was all fine. So I've done that. But from January till June was 6 months. And so the court ordered that the test was to be done in June. And when they come to collect my hair, it was sort of like just under 6 centimetres. So they was only able to test 5 centimetres, which gave me obviously 5 months of negative use. And in that time, it was supposed to be at a contact centre, but what happened was I'm a coach driver, so I was diagnosed with high blood pressure by my doctor.
Yeah.
So of course the DVSA suspended my licence while I sort of got that under control, which meant that a loss of earnings quite significant meant that unfortunately I couldn't afford to do the contact centre because it's like quite expensive. You're looking at sort of like £100 a week just to do that.
Yeah.
And of course I've got rent and bills and that to pay. So I'm due back in court on the 11th of August, and Kafkas have obviously been called to give evidence, but they've not been ordered to do any sort of addendum or whatever before that. So I'm obviously not going to know sort of like what they're recommending by the time it goes back to court. So I guess my question is really, I'm just wondering if you have any sort of experience at what sort of might be likely to happen, and whether I've sort of got any chance with my, defence, obviously.
Sorry, Matthew. Your question is that you have submitted negative hair strand drug tests, so nothing is showing up.
Months.
Great.
But Kafkas wanted 6 months.
Well, look,
my hair just.
Yeah, but the court's not going to say that's not good enough, go and do it again. You've given 5 simply because your hair was a centimetre too short. That's fine.
Yeah, and I gave 2 last year as well.
So there isn't any immediate risk. I think the court could safely deduce that there's no immediate risk here. We have, 3 negative hair strand results from Dad. That shows consistency. I'm not sure there was any questions because you were just telling me stuff. So I'm trying to establish what it is that you're asking me.
Obviously, I'm wondering if they're going to get a little bit funny with, obviously, because, they ordered that contact was to be maintained in a contact centre. But mum was basically saying that, you know, she's on benefits, she can't afford to contribute. Like you say, I had my licence suspended, so I couldn't afford to.
So
I
I
mean,
think
that's
the court.
absolute rubbish anyway, because mum has since been out and she's got a brand new 25 plate car. She's bought a new van. She's trying to buy a static caravan. Do you know what I mean? They've clearly sort of come into some kind of money. And my argument with that is, well, she said that she was on benefits and couldn't afford to contribute. However, that isn't the case. And if she had turned around and said, you know, look, I've got a little bit of money now, I can help keep the contact arrangements going.
Yeah,
I feel like it's a little bit, although I was ordered to do it, she could have helped.
All right, Matthew, what I would say to you is please don't argue all of that in court. Don't what you've just told me.
That was one thing. Yeah, that was another question.
Don't raise that with court. So the fact is that the mum has raised concerns about you having contact with the children. And as a result of that, judges said that you've got to do hair strand drug testing. And until those concerns are eliminated, contact now takes place in a contact centre. You've done your bit. You've put forward lots and lots of results that show you're not doing drugs anymore. OK, but unfortunately, the supervised contact didn't take place. The court will ask why. You'll say
it was. You say supervised. Sorry. It was actually ordered unsupervised.
All right. Sorry. Whatever, Matthew. So it was happening in a contact centre, which was at a cost, and you and mum couldn't afford it. Period. That's it. Now, you then went on to tell me she's lying, she's got loads of money, blah, blah, blah. Please don't raise that. Don't even mention that. Fact is, you couldn't afford it. She couldn't help you out. It didn't happen. So there is no point the court ordering that supervised contact or contact centre contact again. All right. So we go back now. We understand that we've got no drug concerns because of all the results. So let's now look at and let's focus on another way that you're going to be able to have contact with the children that isn't going to cost you or mum any money. That's the issue now that's going to be before the judge. And of course, we need to have a look at what Cafcass is saying as well, because running parallel to all of this, they've done a report.
Yeah, they literally just said that she just wanted 6 months negative drug test, basically, before the contact can sort of progress.
Right.
But obviously, the judge only allowed exactly 6 months from the last court hearing for me to have the test done. And I'm actually going bald. I'm losing my hair.
Yeah.
It's not a sort of like growing. So I only managed to get near 6, but they could only test 5. So I'm just wondering, are they going to drag their heels with that one? I know mum is going to, but would Kafka, do you know what I mean? Mum will say, obviously, you know, oh no, there was supposed to be 6 months, we've only got 5. But I'm thinking, will Kafkas actually say, you know, you're missing a month?
I think what you got to focus on is, it doesn't matter what Kafka says, it's what the court's going to say. I'm not so sure the court's going to split hers over 4 weeks. I think that you've successfully shown that there isn't a risk of drugs anymore.
Yeah.
All right?
Yeah. Okay,
Fab.
so that's my
Well
argument.
done.
I'll just put that in my statement then, basically.
Yeah. Brilliant.
Okay.
Thanks,
Wonderful.
Matthew.
Great stuff. Thank you very much.
Bye.
Firstly, thank you for your advice.
That's
I think
okay.
it's great what you're doing.
Pleasure.
I'm in a bit of a situation with a threatening of a show notice of show cause.
Yes.
I'm in a unique position in which there was a chance of reconciliation that didn't work out. There was a sort of a high level agreement which wasn't signed. We were reviewing it for approval. My solicitor hasn't been great, so nothing has been signed. And since the reconciliation has went a bit pear-shaped, I'm now getting a letter basically demanding that I either agree or I will be threatened with this notice of show cause. I've never filled out a D81. I was never requested to do that. I understand that that's a part of it, but when reviewing his D81 and all this paperwork, it's actually got inaccuracies. It's not stating any finances that he saved, but although it's a very short marriage, no kids, we've not got much in it at all. And, the consent order wasn't signed. I was wondering if you had any experience with that at all. And how does the court review short marriages, no children? How's that looked at? And have you had any experience with these notice of show causes on a draft consent order?
Okay.
Which hasn't been actioned.
Okay.
Nothing's happened on it. It was purely because we were reconciling.
All right.
That
Let me stop you there, because that is a whole lot of information that you want to get from me. You need advice, Preet, is the first thing I'm going to say. How are short marriages looked at? It's not one size fits all with family law, and if you follow me regularly, you'll know that to be the case. We always have to look at the specific family. It's very bespoke, the advice that is given when it comes to family law issues. So how your marriage is going to be dealt with is going to be very bespoke to you, which is why I can't answer that question. Obviously, it's a massive part of family law, so any family lawyer that practices is going to have experience in doing show cause application. For those that are listening, what a show cause is where we have agreed a financial consent order, in this case, is what we're talking about, and it's ready to go to court, essentially. And now one of the parties is saying, actually, I no longer agree with it. The show cause is short, really, for will show the reason why. Show the reason why this no longer applies, because actually everyone spent a lot of time, a lot of money putting this order together, and now one of you back away. So your success in your case, Preet, will lie in why are you now no longer in agreement to it? And I'm not asking you the question, I'm just sort of stating. So that's how you're going to determine if your application will be successful. But it's interesting that you opened up your question with the D81. That isn't really the relevant document. The D81 is for the judge. The D81 is so the judge can get an overview of finances to make sure that the consent order he's been sent and has been asked to make is fair and reasonable. You need to go back to your consent order. So if there's a notice to show cause, chances are this consent order has been drafted and signed by both of you and was in a position to be forwarded to the court once the D81s were completed. So don't sort of focus on the D81, focus on the consent order and why you now feel that's no longer appropriate.
I think the bit that's getting me here is that nothing was signed. I've never filled out a D81. And just had a bit more.
Forget the D81, Preet. The consent order. What's the position with that?
Yeah, it's never been signed. It was just saying a draft was sent for approval. Once I reviewed the approval, I realized basically the big part of the pot of money that's left is being claimed by his father. Although it was for a deposit of our joint house. The house is the main thing that's at stake here. And the deposit was paid by his father, but it was a gifted deposit. His solicitor is arguing that they're going to do a joinder application.
Yeah.
And I'm arguing this is not fair because this was a gifted deposit for a wedding.
Potentially, I mean, if parents are joined, and if this is a significant sum that the parents have put in, and they are joined to the application, there's every likelihood that they will succeed. Whenever I have joined parents to an application, the court generally gives them their money back. And whether it's a gifted deposit or not, the court has the power to hand back the money. They do. So you need to get advice. I appreciate what you're saying about the financial order hasn't been signed. The next question then that I have in my head is, has your solicitor ever at any point written back to say, yeah, we've seen the draft order, we've reviewed the same, and we are in agreement. Please send us a final order for signature. Has that happened? Okay.
That's never happened.
Well, then you need to take some advice. So I can't answer you about your prospects of success on this platform. Go back to your solicitor and say, right, let's go back to the drawing board. Tell me, what my chances of success are. Because if you have little chance of success, you don't want to throw good money after bad. In other words, you don't want to pay your solicitor to do more work if you're not going to get anywhere.
And I suppose one sort of follow-up question I have is, when things are gifted in terms of a deposit, is there a view that this money can be returned, even though that is clearly stated in the property there was no interest in getting it back? I never knew that was a thing.
The court have the power to do that. The court have the power to do that.
Okay.
So I had a case where the parents over a period of time had given their son £160,000, and it was sort of drip fed to help the couple with the extension. There was no papers signed. There was nothing to indicate that they wanted it back ever. But they had a building company and they were sending round the trades and they were paying for materials, etc., etc. And the court ordered that they had it back. So the court does have the power to do that, is what I'm saying, which is why you really need to get your solicitor now to give you some advice about how successful you are going to be. And that won't be difficult.
Yeah, no, perfect. Thank you so much.
Pleasure. Thanks, Preet. Bye-bye.
Thank you. Bye.
So basically, in 2021,
Yes.
been to court for a child arrangement order.
Yes.
And in the court order, it states that to pick up the kids from my house on Friday evening and drop them back to my house on Sunday evening and half of the holidays, which were fine at that time. But meanwhile, the social services got involved, the child protection got involved because of the harassment, stalking and abuse.
Yeah.
So they changed the visits for that to pick them up on Friday evening, Friday from school, and drop them Monday morning to school.
Yeah.
And use the school as a pick up and drop up point.
Yeah.
We've been doing this for the past year, which was brilliant, worked perfect, no problems.
Yeah.
Now the social services closed the case and Dad wants to revert back to the original court order, which, to be honest, I don't agree to use my house to pick up the kids and boys. What I can do?
Well, you have to be guided by the latest court order. We can't just go back and pick and choose which court order we're going to follow. It's the latest court order that has precedence. That's the one that the court's going to be guided by.
The last child arrangements weren't done by court, were done by the child protection chair.
So it's not an order, is it? So I'm going to repeat what I said.
Exactly.
So you've got to go back to the last court order that was made by the court. That's the one that has precedence.
Okay, so basically just have to use my house again.
If that's what the last court order says, be guided by that. Now, if you feel that that places you in a vulnerable position, the matter has to go back to court.
Oh, okay.
Okay? Because what you can't do is take an order that puts someone, and follow it if it's putting someone directly in danger. Or you feel, intimidated or whatever. So then that's when you go back to court and say, Judge, this is the last order that was made. However, if we stick to that order, then we're going to have, issues here, safety, welfare, whatever it is. So we need to revisit the order. So it may be that you need to make an application to the court.
So I need to make the same application like C100 and start all over again?
Potentially, yes. I mean, I think you need to get some advice, Simona, because I don't know enough about your case to now tell you which application you need to make. So I think now you've reached the point that you probably need to have a chat with a solicitor about, what your next steps are.
Oh, okay.
All right.
Thank you so much.
No problem. Thank you. Bye-bye.
I have two boys whose dad's on the birth certificate took me to access for nearly 5 years ago, but he pulled out of the court and there wasn't any access granted. My boys are wanting to change their name. How do I go about this, please? No contact with the boys for 7 years due to DV arson attack, and he did serve a custodial for this.
Wow.
The boys are 7 and 9.
Okay. So the first thing I always say when people ask me about name changes, and it's worth repeating it, is once the children get to 16, they don't need anybody's permission. They don't need the people who have got parental responsibility. They don't need their permission. They can just go off and change it themselves. Okay. So because obviously these boys aren't 16 yet, if dad is named on their birth certificate and therefore has parental responsibility, she is still going to need his consent. Okay. Now, if she doesn't get his consent and goes ahead and changes it anyway, the risk to her is that he can, if he finds out about it, object. And once he does that, the court's got the power to change their names back. So I always think it's better to serve him, make your application if you can't get his consent, to serve him with the application and do it properly through the courts. That way, once it's changed, there's no risk of the courts having to change the name back again. And they can do that if she... And the reason I say that is because I've known lots of parents over the years that say to me, oh, I didn't get his permission, I just changed it. Deed poll aren't going to stop you from changing it, but there's a risk that it could go back. And of course, that's really upsetting for the children. You know, if the children have, got a new name for a couple of years and then dad comes back on the scene and finds out, he could then go to a judge and say, don't agree with that, not happy with that at all. So do it the right way. Ask him for his consent. If he won't give it, make your application to the court. It's a C1.
Just to add a little bit to that, she said there's an indefinite restraining order in place.
Yeah, that's okay. Doesn't matter. Because she's...
So just go through the courts. And
absolutely. Yeah? She still has to serve him. We serve via email or via post. Let the court know there's a restraining order. They're not going to do anything to breach that. You know what I mean? But she's got to serve him, because if she hasn't served him, the court's hands are tied, really. Let the court know there's a restraining order, and obviously they can't go to court together, but the court will sort that out.
My estranged husband for 6 months has no contact with my children.
Yes.
And is not changing his address, so child maintenance can't get in contact with him. Will this be resolved through the financial order?
Not really. In a financial order, we can include... what we call child periodical payments, which is money for the children. It's usually in addition to child maintenance, and it's usually to cover things like school fees or nursery fees or things like that. But child maintenance doesn't apply to married couples only. So what I mean by that is if you're not married and you separate, you're not going to get a financial order. You're still going to get your child maintenance. So if he's avoiding child maintenance, or child maintenance can't find him to get the money off him, then the option to her could be to get a financial order, obviously if she's been married to him. And then as part of that, we can try to include some additional money for the children.
Can my child at the age of 16 refuse to go to see the other parent if he doesn't want? And while he's not 16, does he need to go to dad's home if he isn't there for weeks and weeks?
Look, at the end of the day, once they get to 16, the family court no longer make child arrangements orders then, because they are of the view that the children will vote with their feet. So after 16, absolutely, the child can make their own decisions and the court won't get involved. Prior to being 16, the child's voice is still listened to. So once the child gets to 13 or 14, really, the court then starts to get involved with, well, why doesn't he want to go and see the dad? And if we've got safeguarding concerns or anything like that, the court won't force him. They won't force him to go. If a child is a lot younger than that, sort of below the age of 12 or 11, it's difficult to give a definitive age, because obviously children mature differently. But if the child is a lot younger than that, then it will still be a decision that's made by the adults. But once they hit teenage years, I think it's near on impossible then. If the kids don't want to go, you can't really force them to.